Hi, I'm Adib Ray. I'm a corporate attorney and a volunteer at Inventive. And today we're with Mr. Bautran, a patent attorney and the founder of PatentPC, a patenting law firm that helps businesses protect their intellectual property, get patents more effectively and faster, and go to market more securely. So, Mr. Bautran, if you don't mind, could you please introduce yourself and tell us how we'll go forward with helping startups protect the intellectual property?
Well, first, I want to thank Adhib for inviting me to present on this very interesting and vital topic for founders and for inventors. IP is a great way to, number one, increase the value of your company, and number two, protect you from copiers. So with that in mind, I like to use a transition to a slide deck where it will talk a little bit more about myself and the process, if you don't mind. So I will share the my slide deck.
Sure, let's do it.
All right. Um, so basically, so Asif, are you able to see the full screen of my presentation, or are you seeing the PowerPoint?
Yeah, I am able to see the entire presentation.
Yeah, the full screen, not the other. Okay, well, great. Okay, well, today we will talk about a three-step strategy to protect your innovations. In particular, this particular slide deck is talking about software, but the principles are applicable to, whether or not it's mechanical or electrical or chemical inventions. So, a little bit about myself. It's not moving. Is it moving? The screen moving? Yes. Okay. So a little bit about myself. I have 25 years of experience as a patent lawyer. I was with a big law firm, and then one of my client was a startup company that turned out to be making the Invisalign dental product. So they hired me to become their associate general counsel once they got their Series A funding. And with that experience, I saw the differences in practicing in-house as an in-house attorney with a startup versus from an outside a big law firm. Um, Fortunate for me, Invisalign went public and it's become a very well-known brand. Since then, I also helped Shutterfly, which I think is also became a well-known company. And I've also helped numerous startups such as Monolithic 3D that makes 3D chips, and they've licensed some technology to the biggest names in semiconductor technology. Um, so this repeat what I've just said. Basically, I was the main architect for Invisalign and Shutterfly patent application. And again, here you see some examples of that work. The Invisalign technology really has three components. It has a software computer-aided design system, so that's software. Then it has a fabrication component where you have 3D printed technology to fabricate the retainer that you see here. And then it also had the scanning technology. So how do you scan the mold, the rather that structure you see at the bottom of figure one? How do you scan that so that you become a digital model? So there are three different technologies we dealt with. In the case of Shutterfly, which is the patent you see on the right, when they started this 20 years ago, they were really worried about how they store and archive large quantities of photographs. Back then, megapixel, but now we can easily do 100 megapixel patent. So the way they solved that was through different tiers of storage. So the older content is stored optical disk, then the intermediate content is stored in large data drives, and then the short-term content, the things that you just recently uploaded, that then is stored in a flash in memory, basically. So my point here is, as a startup, you're raising a baby, and the baby is exposed to significant threats. So, for example, this is a Wall Street article that details what happened when a big company reached out to a small company. The Wall Street, journal, as you see at the bottom, it says when this company comes calling, it's a kiss of death. And that's unfortunately the fate for many startups. And so here is more detail on how the big company would come in and basically take advantage of the small company's eagerness to expand the marketplace. So the best way to protect this is with patent protection. Here's another example, another big company that ate a small startup called Photo. What happened there was Photo was excited. It had a new technology and they were very excited about it. They approached Facebook for a distribution arrangement. Facebook says, "Oh, we love you. Why don't you just, we'll give you the API to work with us." And then, lo and behold, a few months afterward, they got shut out of the store. And then Facebook introduced an identical clone. And because this company didn't have patents, the only tool that they had was to allege that Facebook was violating unfair competition or antitrust law. And as you know, that's really, really a very weak cause of action, because you're basically saying, well, it's unfair for Facebook to copy me. Well, that's not going to go very far. And they lost their lawsuit. So had they had a patent on it, that situation would have changed. So another example, your brilliant Kickstarter could be on sale before you finish funding. There are plenty of stories where you go to Kickstarter, you upload all your contents and how exciting your product is going to be and what it looks like. And of course, you don't have any of this in production yet, right? Because you're fundraising. And if I were playing an evil guy, I would just simply look at the Kickstarter and I would just decide on which one got successfully funded. And I say, okay, they've proven the market for me. Now I'm just going to produce it. And there are examples where offshore companies produce the end product before the Kickstarter completed their funding. So then how do you protect yourself with this? What you need to do is to use the patent system. And as I've alluded earlier, patent is not an expense. It's an asset you're building. Because when you go to an investor and you say, hey, my company got a patent asset, and that company, another asset happens to be valued at, let's say, $250,000. Investors are generally not going to push back on you because patents can be valued anywhere from 100,000 to 100 million, or even a billion in the case of medical. So 250,000 is certainly something that they're not going to push back on, right? And so you're increasing your company valuation, but then you also protect yourself from copy. So we recommend a 3-step guide. Number one, if you have just one patent, it's going to be, they're going to say the patent's invalid. So what you got to do is build a diversified patent portfolio. Number two is you got to control, because you're building a portfolio of more than one patent, cost is an issue. So you got to control patent cost. And part of that control is that you select law firms that know the technology, that can do this very efficiently with their own computerized workflow, and that you also, after you built up your portfolio, you periodically prune and figure out the patents you don't need, and you sell them. So that's how you monetize the portfolio. The one that you're using in your production, you keep that, of course, but you don't need, then you sell them or you license them. So strategy number one, build a diversified IP estate. So what you need to do is look at your product, identify the key features and the competitive differences, and then you focus on patenting those competitive differences, things that you don't want your competitors to be able to say, oh yeah, I have the same too, right? Then after you've done that baseline production, baseline platform, then you identify what new features you're thinking of next. So you protect that. And you need to file this as quickly as you can, because in all parts of the world, the people who file first gets the patent. It's not who came up with it first. It's who filed it first. So strategy number two, you have to cut costs. As you know, these days, big firm lawyers charge around $1,000 an hour. And at that rate, the cost can really rack up. And so you need to find a law firm with the right technology and also with the right domain expertise, so that you're not paying a lawyer $1,000 an hour to learn about your technology. So that's what you look for.
So Bao, just to come back to your previous point, so as you know, we at Inventive we have a software that allows startups to get create their patents faster, and at least the first draft, for at almost a very low cost or almost free. So if these startups who create these drafts go to you, so you create these patents based on the drafts, right? Or is it something that you have to do from scratch?
Well, of course, if
And does it help in lowering cost?
yes, of course. Part of the lowering of the cost is that you give us very high quality patent disclosure. And if we've seen a wide range. We've seen people come to us with just a page, on the back of a napkin, and then we've seen people that give us 40 or 50 pages of detailed diagrams and descriptions of how the invention work. Well, of course, if you give us a lot of detail, it's going to be very easy for us to take those and clean it up and then put it into the proper patent format. So it'll save you money. And so, yes, the inventive approach is one way where you can help yourself to save money by using the structured output and giving that structured output to us as the initial point to draft your application that we will file with the patent office. So yes, that's the mechanism for saving money.
I see. Also, one more question, which is that I was surfing, through the flat fee patent lawyers. So, is that something that helps save costs? And also, I saw that PanPC also provides flat fee patenting services. So, how does that relate to those lawyers who work at hourly rate? And also, you said that patent lawyers do not apply the latest in AI to counter the patent office use of AI in rejecting applications. So what does PanPC does separately, to get your clients lower cost, but also getting their patents more effectively made and crafted?
Yes, thanks for the question. A very insightful question at hit. So, typical big firm lawyers, they bill around $1,000 an hour. You can just Google this up online, if you think that that number is excessive. But that's actually by this year, it's actually slightly low. So at that rate, if they spend an average, the industry average is spent around 20 hours on a patent application. So you can see, you can do the math. It's $20,000 just for them to prepare a patent application, right? That's not to learn the technology. And so many of these lawyers, before they, if they're not familiar with your technology, the first thing they're gonna have to do is spend an hour or two kind of understanding what the basics are, and that's very conservative. You'll spend a lot more than a couple of hours learning about a new technology that you're not familiar with. But um, so if you use a lawyer that's not quite knowledgeable about your domain, and they bill at the big firm rate, you're going to end up with a big bill. And of course, that's not what we want to do here for inventive, users. We want to show you how you can cut the cost. So at our firm, how do we do that? First of all, we have a computer-aided technology that basically takes your information, generate a first draft for us to review and check the accuracy. What we also do is we allow, collaboration between you and us, and we typically involve multiple eyes at it. So there'll be another person who reviews your application. In our computer-aided platform, they run diagnostic on the text already. So you're already talking about 4 eyes reviewing. So so it's high quality, and yet we can do it very efficiently because we have our own AI CAD automation stack to organize the workflow and to check the quality, and then we rely on multiple eyes. So that's how we achieve low cost and high quality. If you just look for really, really low cost, I'm sure you can Google around and find some advertisement out there from some of our competitors that are extremely, like, 2 or 3 thousand in cost, but their quality, they'll give you probably about 4 or 5 page patent application. What you want in an application is a very in-depth discussion of your technology. And why is that important? It's important because, number one, when you go to the patent office, what you will do normally is you try to claim as broadly as you can. And the examiner at the patent office, his job is to push back at you to say, hey, look, you're trying to claim something so broad that it's going to block the existing, products, or it's obvious by using existing patents. So he will push you back on the claim. And what we want to do then is if, in a negotiation, it's a give and take. So if you have a very deep disclosure with 20 or 30 pages of description of how it works, unlikely that two other patents will work when you combine them, will work exactly the same way. So what we can do is we can point to those 30 pages of discussion of how the technology works, and we can just select a paragraph on how it works that differentiates from his rejection by combining two or more prior art references. So the quality is in the depth of the disclosure, and as well as in understanding how your case will likely be examined at the patent office. So hopefully, did I miss anything, Adhib? Or any point you were raising?
Oh no, that was extremely insightful. And yeah, that was extremely insightful. I'm sure that businesses that are looking to protect the software will do a lot of help for understanding how to protect the software, including the factors that you mentioned, that inventions must be non-obvious, novel, and must have some utility. But yes, please proceed with the strategy number 3. I'm really excited.
Great, thank you. So the strategy number 3 is to cut costs and potentially to raise funding for your startup. You would want to prune your patents, right? You have a portfolio. As I said earlier, many people just say, I have one patent and that's it. That's all I need. Well, the problem with just having one patent is that when you assert it, somebody's always going to say, oh, that patent is invalid. Now imagine if you have a portfolio of 10 or even 17 or 20, and you go out and somebody's copying you, and it's very hard for them to have a straight face and say, oh, all 18 or all 20 of them are invalid, right? So what you want to do is you want to have a portfolio that crisscrosses you like this. And just like in the stock market, right? In a stock market, you don't want to invest everything in Apple because God knows if Apple collapses, you're gone, right? You want a broad-based basket of different claims, different technologies, and that will provide you with the flexibility and the survivability that you need. Now, part of that problem then is when you have a portfolio, it's going to be expensive. You're thinking in the back of your mind, I don't have money for 20 patents, right? So what you should do is lay your foundation, file your first case, and then as you develop your technology, you then continually update that with patent application. And then as in going through your startup journey, sometimes, well, actually most of the time, the company will pivot. They're going to say, oh, yeah, our original direction was this way, but by now, well, we're going this way. And so some of the patent that you originally filed a year ago, they may have been in the old direction. So what do you do with that? Yeah, do you kill it to save money? The answer is, well, you balance that. If the technology is so rare that nobody's ever going to use it, then yeah, kill it. But if you think that the industry might still be able to use this, I would basically get that patent application, those to issue as a patent, and then I would then try to find some potential candidate who may buy or license, and that's how you would raise funding for your startup. So that's why I suggest that you really want to think about a portfolio strategy because it might give you some monetization capability early. So then it naturally comes to the question of why PatentPC versus the big law firms? Well, this is a shot from Blue Iron, so it's not from us. But you can look at it from the lifetime, from starting the file to the ending of that. It may run you $56,000 if you use a big traditional solution. And a lot of time, if you just rely on single patent, about 70% it may be lost because the defendant would say it's invalid, right? In this case, we're talking about software. So if you're involved with software patenting, there are some additional hurdles, and we know them. So these are some of the extra scrutiny at the patent office for software invention, and it's a complicated path. But you don't need to know about that. We are the expert that will.
Just to Yeah, just to summarize, so basically patenting software is extra hard, but is it also that patenting algorithms is also extra hard? So if somebody has an algorithmic invention they want to patent, is it the same?
Yes. Algorithm and
Okay.
software is treated as the same thing. And in fact, if you're doing AI, it's also going through the same examination process. There are tricks to bypass this complicated charts. And the trick is basically to focus on describing your invention correctly so that it discusses how the invention improves the computer performance, be it in speed or be it in the out product. So for example, if you have a great compression algorithm and you say, oh, well, this thing improves the compression by a factor of 2, that's something is something we should discuss in the application. Um, and the PTO is now applying AI to check your application. So you should be also be thinking, checking to see if your firm is using AI as an antidote. So we have done AI for a long time, starting from the neural network patent application, things we done back in 20 years ago when neural network was like 100 layers. Now it's in the billions and the trillions, right? We know how to do software patent application, and we're used to it. And we have a pretty high allowance rate because our software ability to to look at the history of the patent examiner, and also our diagnostic tool. We even have our own.
About this, yeah, about this is actually quite impressive. Like you have such a high allowance rate. So is your strategy to also focus on using patent portfolio so as to make the entire patent application rock solid, so that the different aspects of patents for innovation gets patented by different patents? Is that how you increase your allowance rate compared to other law firms out there?
I think it's threefold. First is we focus on a very high quality patent application that's described in depth. Our patent applications tend to be between 40 to 100 pages in length. Of course, 100 pages is going to cost you more, but with a 40 pages, basically a typical startup type of description of the processes going on at the machine. So we have we like to get very in-depth discussion of the technology. Most firms they don't have enough time to do this, so they build very short 10, 15 pages this application. We tend to be doubling that because we really get deep down into your technology and describe how it works. That's number one. Number two is invariably 80 to 90% of your patent application, when you file it, you're going to get a first office rejection, meaning that the patent office is going to reject you no matter what you do. Even if you've done a full-blown prior art search and you give them the closest piece of prior art to the examiner, they're going to go and do their own search, and they're going to try to say that your invention is obvious. So how do we solve that? It's a human-to-human communication, right? So the way we do that is when we get an office action or a rejection from the patent office, what we do is we first draft a response, we send them to you to review, and then after everything is approved, then we request an interview or a conference call with the patent examiner. In that interview, we would say, hey, we would ask you as the inventor to give us a 5-minute elevator pitch on why your invention is so great. So it's coming from the mouth of the horse, you as the inventor, and you put a face to the invention, right? Then we discuss with the examiner why the combination wouldn't work. And then we'll hear his feedback. And we believe that that's the best way to address rejection, is to maintain an open line of communication and hear out all the issues. Many of our colleagues in the big firms, they just simply file documents back and forth without talking. They don't interview the examiner. And because of that, if you just submit paper, the patent office is sending you a piece of paper that says your invention is obvious, and then you send them back a piece of paper that says no, it's not, you're wrong. It's just going to go back and forth. So we believe that our approach is the best approach in terms of providing full communication, providing a human face to the invention, and that's how we have been very successful. Is that we open a line of communication. It's automatic with us. Whenever we get a communication from the patent office, 100% of our cases is we establish a line of communication with the examiner and involving the inventor because the inventor is an important part of this, and they should be involved, right? And so combine that and combine our experience of 20, over 25 years, over a quarter of a century in doing this, we know exactly what they're thinking. How they think, how they work, how they get rewarded at the patent office, and how they don't get rewarded. We know all of the history because we have tools in-house that would detect, okay, this particular examiner, he rejects patent application. It takes 5 or 10 responses to get it passed. Then we can recommend to the client, given that history, we recommend that we just go ahead and do an appeal. Or if we see that the examiner's history is that he'll work with us, then we work with him. So we provide a 360-degree sphere of information to help you as the inventor know what path is the best path. And so that's how we believe that our approach will get you the highest possible result at the lowest possible cost. I hope that's clear.
Yes, that was amazingly explained. I now understand why you have such a high allowance rate. But yeah, please do go ahead.
Yeah, and so yeah, so here is a patent on our own process on how we do the patent application. So we have a patent on our own patent process. So we are not only I guess so we drink from the same dog bowls that you do. We ourselves are inventors. We understand what inventors do and think. So here's an example of basically some of our patent system to do patent applications. We take your drawings in, we describe them in full, and we check the quality. So this slide more or less repeat what I just spent 5 minutes with you on. We use AI analytics to help us, and we use computer-aided design tools to make the patent application to improve the quality of it, basically. So there's a checklist on your work product. This is done so that it improves your out of allowance. So here are a few, I'll go quickly on this so that we'll leave more room for questions from you out here. But, this is a case study of a company that's public, and they obtained over 30 patents in the span of 3 years. During the time of which the stock rose significantly, and that's basically the CEO's comment on us. This is another company that's it's a semiconductor, a fabless semiconductor, where they build integrated 3-dimensional chips. Traditional chips are single layer, 2-dimensional, and this one builds chips that are 3D, and because that's the only way you can increase density is now to grow 3D, because right now I think our resolution is at 2 nanometers, which is we're approaching the upper limit of our ability to make small dimensions. One of these, the equipment to lay out a 2 nanometer is just astronomically expensive. So monolithic 3D, what they do is they stack things vertically, and that's the way you now improve on your density. They have 211 patents issued with us. They recently licensed one of the biggest electronic companies, and it's one of those brand name companies that you know about. They license some the patent portfolio, and it's not easy. I mean, to make one of those big companies pay you, it is no trivial task these days. Sysbay is a startup in microbial technology, and we basically help them build a very broad-based U.S. patent portfolio, and then we will help them in international filing. So they have IPs in Mexico, in in Malaysia, and it's important because AgTech is something that's because of the cost of shipping things. It's better off that you do it locally. So they have local partners who make the microbes, and that's where international IP right becomes important. They were also thinking about following the Coke strategy, which is Coke has companies that are in separate. Let's say you have a Mexico Coke, Coca-Cola, you have Russian Coca-Cola, Chinese Coca-Cola. So you would have different companies where the local investors invest in those companies. And so international strategies may be appropriate for certain industries. So, and that's the end of my presentation. Let us help you complete your hero story. You've come a long way from being a startup, right? That's a lot of work, and congratulations to you for coming this far. We can help you move that needle a little bit more through the IP system. And we do that by increasing your company valuation. We protect your go-to-market because we have technology that can help you get to the first to file timeline. And that's important because the patents are granted to those who file first, not to those who think about it first. So we help you build your diversified portfolio, and that has contribute a lot of value to your company. And we've spent 25 years helping various companies, some public, some small, and a few that didn't make it in the world. But that's very common in startups. We'd like to help you skip the hard part about IP. Just call us. And so here it is, and we look forward to meeting you.
Thank you, Bob. That was a great presentation. I'm sure it'll be really helpful for the audience at Inventive. But before I let you go, I just have around one question for you. So nowadays there is a trend, especially with monolithic giants like Google, who have kept their algorithms secret. Plus, we have strong trade secret protection in the U.S., the DTSA and the UTSA statutes. But this doesn't apply to all startups, right? Especially if you're trying to protect your business innovation as a trade secret, you are incurring a giant risk. So, as a patent attorney and an intellectual property expert, what would be the trade-offs that you see startups making, and what would you recommend? Like, when is it the right time for startups to actually think about considering, that now I need a patent or now I need to protect an IP? Now is the right time.
Sure, trademark is a part of the intellectual property, domain. So it has its uses, and it has its upside and downside. So what's the upside of a trademark? If you can keep it secret, your IP can last indefinitely. So a prime example is the Coca-Cola formula or the Kentucky Fried Chicken formula. Those are well-known trade secrets. Those are, those secrets are kept behind vaults, basically, right? So they're secret because people spend the resources to protect them as a secret. So you need to have all those procedures in place. And if you miss something, that information somehow leaks out to become public, then it's public information and you've lost that IP asset completely. So so the advantage is trade secret is that they can last forever. The downside is you have to have the proper procedures in place to track and protect and make sure that people know it's a secret that you value. So so you have the proper structure in place. And the worst of the downfall is if somehow somebody else independently comes up with that trade secret, then you're gone. So you've got to balance that against the patent. What's the downside of a patent? The patent is going to disclose your secret because you're required to, basically, right? But a patent will block anybody from implementing those things that you patented. And so those are the balance, the advantage and disadvantage you got to weigh. So the way I would recommend this is this: if for the software industry or for the chemical industry, if you're doing things that are behind your factory, behind a firewall where nobody can see what you're doing, trade secret is perfectly appropriate. The example is Coke and the Kentucky Fried Chicken formula and also your AI training algorithms, right? Those things you do behind your office or a server, nobody ever sees. So those are perfect candidates for trade secret. What is not appropriate is in the customer facing product, because that can be reverse engineered, right? Anything that you do that, you ship out your executable codes, or you render that on your browser screen, all of that, it can be reverse engineered, or it can be, in the executable, you can certainly have decompilers that tell you what that software does. Or sometimes when you don't even have the code, you can look at it and say, yeah, I know how to implement that. I mean, don't tell me you don't, Amazon has a one-click path, right? Don't tell me that, oh, it's a secret because I don't know how to implement a one-click order thing. Once it's out there, it's gone. So Amazon was very insightful. They patented the one-click patent because that's something that's visible to the user, and that once it's visible, once the idea is out there, people can implement it freely. And as long as they didn't steal your trade secret in implementing it, they're free to do it. So Amazon patented the one-click concept, and they forced companies like Apple to pay. And Apple, they never pay, as you saw in the Wall Street Journal. I mean, Apple is not used to paying for IP, but Amazon was able to do that. So that's the power of a patent. Hopefully
Yeah.
that answers the question, Hit.
Yes, that was really insightful. Also, I'd like to add that startups that not patenting are actually incurring an extreme risk because, like, if you have a business model that is completely hedged on one, technological innovation or one software, and you're not patenting it, and if it gets leaked, your business is dead. So if you have a business that runs on a technological innovation, just rush to your near and get it patented as fast as possible. And of course, we have you for that. Well, thank you, Mr. Bautran. It has been amazing talking to you. And I believe people can reach out to you at btran@inventive.org, as well as from your PanPC site as well. I thank you for collaborating us at Inventive. It was really nice for our audience as well, who are predominantly startups. That's it from my end. Thank you.
All right, thank you. Uh,